We will go to our second guest, which is Mr. Steffen Weiß, member of the Board for International Affairs, GDD Germany, also member of CEDPO, and his subject today is about damage claims and enforcement trends by the German regulators. Steffen, thank you.
Thank you very much for your kind introduction. Yeah, I want to talk about recent activities in Germany covering damage claims and enforcement by regulatory authorities in Germany. Having a privacy champion network established within a controller or processor definitely helps to avoid such risks. And I just want to give you some insights, what's going on, what's happening in Germany at the moment regarding the two topics. First of all, I want to give you a brief overview of the GDD, my association, or I'm being part of. We are a non-profit organization founded with the first German Data Protection Act in 1976. Germany has quite a large history when it comes to protecting personal data from a regulatory point of view. And then our first Data Protection Act officially started in 1977. The GDD is helping its members with guidance, with training, etc. We also have one pretty much unique feature at the GDD. We offer a hotline for the DPO, so they can ask us specific questions. We cannot take part in projects because we're lacking time, but if you have specific questions, you can address these questions to GDD staff and you will get an answer. And it's mostly the DPOs asking us any questions related to the GDPR or national implementation law, the Federal Data Protection Act in Germany. We also have working groups in Germany, which are organized by supporters of the GDD. So in case you're a DPO or staff, data protection staff within a company, you can attend the working groups, even without being a member of the GDD. And there you can discuss a variety of topics. And mostly you will also receive presentations from privacy experts or data protection experts on any specific topics you want to have an eye on. We also did some lobbying on the DPO, of course, because one of our core missions is to support and help the DPO. And when the GDPR was introduced, or the first draft by the Commission, we had a very close eye on the article covering the data protection officer. On the one side concerning his or her mandatory designation, which also has a large history in Germany. Even under the GDPR, we have specific provisions in Germany covering the mandatory designation of the DPO outside of Article 37 GDPR. And during that time, we also tried to get an article within the GDPR with an extent interpretation of a mandatory designation. In the end, Article 37 is as it is. It is quite complex to define what is the processing at large scale, but still in Germany we have this mandatory designation, just looking at the threshold of employees at a controller or processor regularly processing personal data. But that's enough about the GDD. I want to jump into the main topic today. First, I want to start with damage claims. As you all know, the GDPR has a certain provision covering damage claims, Article 82. So any data subject who is suffering a monetary or non-monetary damage from an infringement of the GDPR can claim compensation by a controller or processor. In Germany, this has been quite a change, because in Germany, under the Federal Data Protection Act, before the GDPR came into place, we did not have a provision addressing non-monetary damages for a breach of law. So this was quite a fundamental change for Germany. Suddenly, there was a possibility to claim compensation for non-monetary damages, and people were quite nervous, especially companies. How would this evolve? And this was one of the main reasons I had today for presenting you the topic concerning damage claims. Is the fear sufficiently grounded or not? Do we have the fear that the requests are getting massive? And how are the courts reacting? I want to present to you 4 cases, selected cases in Germany, addressing non-monetary damages claimed by data subjects. First of all, let's go to North Rhine-Westphalia on the western side of the German map, the Labor Court of Düsseldorf. There was a case where an employee was requesting a copy of his data from his employer. As you all are aware of Article 15, you have the right to receive a copy from the controller who's processing your personal data, regardless if it's an employment relationship or if you're within a customer company relationship. In that particular case, the employer was reacting delayed to requests of receive information regarding the employee. And also the information that was given to the employee, I think 3 months after the actual request or the initial request, was not complete. It was incomplete. And that's why the plaintiff was requesting a non-monetary damage for infringing Article 15. Article 15 is quite controversial in Germany. It's being discussed quite controversial here regarding the extent of this right to receive a copy. Does it also apply to internal information within the company, the controller, for example? Does it also apply to emails being sent to the data subject? There have been judgments from courts in Germany interpreting Article 15 very differently. Some saying internal notes are not covered by Article 15 to receive the right to receive a copy of the data. Others saying yes, we have to interpret the provision quite broad because it is any information related to the data subject. Regarding emails, some courts were stating that the controller is not an archiving body for the data subject. So in case there has been a communication via email and the data subject has received emails, this email is not subject to the copy the data subject is requesting in the course of Article 15. But in that specific case brought to the District Labor Court of Düsseldorf, we had a delayed response. We had a incomplete response to a request under Article 15. So the court in the end granted 5,000 euros to the plaintiff. The reasons for this were quite different. One thing the court was stating is that the access right is a fundamental piece of the Charter of the EU in Article 8. And also we had a quite obvious breach of Article 15 of GDPR, which led to the court to the assumption that a compensation of 5,000 euros should be considered sufficient. Another case being brought to the District Court of Hamburg in 2019 was the case of a tattoo artist. This tattoo artist was offering a form on his website offering the possibility to make an appointment for getting a tattoo. And the plaintiff was trying to get an appointment for getting a tattoo, but the data entered into this form on the website was disclosed to the internet. So there was a lack of technical and organizational measures at the side of the tattoo artist. So the plaintiff seek compensation for a breach of Article 32 and also a breach of Article 6 because there was a processing of personal data without a legal basis. The exposure or disclosure of personal data lasted 6 weeks, by the way, in the internet. It was publicly accessible. In the end, the Court of Hamburg did not grant any compensation to the plaintiff. The court was saying that you really need to prove a damage caused by the breach of the GDPR. In that particular case, the plaintiff was fearing disadvantages of this exposure of personal data in the internet, leading from an employer who was interested in the private life of this person, also concerning other third parties getting some insights on the private life and this specific interest in tattoos and anything related to tattoos. But this was not sufficient in the view of the court because the plaintiff could not really prove a damage or substantiate a damage caused by the breach of the GDPR. So in the end, no compensation was granted at all. Another case having been brought to the courts in Germany was taking place in Cullen on the left-hand side of the slide here. We had a case where 6 pages of account information was sent to a wrong recipient. This was being sent from a controller of personal data, I think it was a telecommunication company, to a lawyer of the mother of the plaintiff. The mother had passed away, and this data should have been communicated to the plaintiff, but not to the lawyer of the mother. In the end, also no compensation was granted by the court. The arguments from the court reducing this compensation to €0 was that this breach of the GDPR was considered trivial by the court. It was only, I'm just quoting here, 6 pages of personal information. It was not, there were no special categories involved of personal data. It was a one-time breach of the GDPR. So in the end, the court did not see any grounds for granting compensation in that particular case. Then but very interesting in the arguments in the court, something which has been brought to my attention was that the court was saying, in case we want to define a compensation granted to the data subject, we need to look not only on the specific case, the data is being affected, if it's a one-time breach or multiple times breach. We also can have a look at Article 83 of the GDPR when it comes to administrative fines. There are certain conditions which the supervisory authorities apply when sanctioning a breach of the GDPR. And the court took these conditions from Article 83 and took them over to this specific case to assess how much his compensation would be in the end, which led them to 0 euros. But still, it was interesting to see that they took this, the conditions for applying from a different aspect of the law covering administrative fines and not the ones from the court. The last case I want to present to you was brought to the District Court of Darmstadt. It was the case of an applicant. This person was applying for a job at a bank via a recruiting portal. And the bank was replying to the application with certain information on the job and a certain salary they could offer to this person. But they communicated this information to the wrong recipient, to another person of another holding this plaintiff was working for. So we had the case of an unlawful processing with the case of an unlawful disclosure of personal data to the wrong recipient. And we also had the case of the data breach. And especially because it was a data breach under Article 33 and 34 GDPR, the court stated that the plaintiff should receive a compensation of 1,000 euros. One of the arguments was that this applicant's or the information concerning this applicant was very sensitive professional information. It was not any specific category of personal data under Article 9, Paragraph 1 GDPR, but in the view of the court, it was sensitive information with regard to the employment relationship and how much salary this person would get. And also, the court was stating that the plaintiff could fear reputation issues when his existing employer was getting this information and receiving this information that this person wants to leave the company, and therefore there was the danger of discriminatory actions from the employer, which led the court in the end to a compensation of 1,000 euros for the plaintiff. But if you look at all these cases here covering non-monetary damages in Germany, we must admit that the courts are quite reluctant when it comes to the amount specified for a compensation for the data subject. So the fear in Germany that there would be a fundamental change of cases being brought to the court covering non-monetary damages, we must say that the number of cases increases, but we also can say that the courts are not in the position to really raise the bar when it comes to the compensation numbers and figures. They still remain reluctant when it comes to really big fines, if you want to call it like this, towards the data subject or the plaintiff in the specific case. Moving on to enforcement actions. We've talked about the right of compensation, and now I want to talk a bit about DPA enforcement actions in Germany. So let's start with one slide here covering the Directive 95/46. You are all aware that the Directive 95/46 did not specify any guidelines regarding the possible administrative fines for a breach of law, which led to a different interpretation in the national data protection laws. Such as in Germany, we had a maximum fine of 300,000 euros for a breach of the Federal Data Protection Act. But also our law at least stated that the fine shall exceed the financial benefit to the perpetrator derived from the administrative offense. So there were, of course, cases where this number could be increased because the perpetrator or the company breaching the Federal Data Protection Act really had a financial benefit, such as the case where you're selling personal data, you have a financial benefit, and therefore the regulator wanted to have this possibility to increase the monetary sanction. you had other member states in Europe where you had really few fines stipulated in the Data Protection Acts, at least at an early stage or early versions of the Data Protection Act, such as in the Netherlands, where they had in the earlier versions fines up to 4,500 euros only, in comparison to up to 600,000 euros under the Spanish Data Protection Act. So it was quite different from a regulatory framework, but it also was quite different from a supervisory authority approach, how to apply the regulatory framework to the individual cases, which led, to my assumption, to a difference when it comes to sanctioning. We had a huge difference concerning the northern supervisory authorities to the southern supervisory authorities. The highest numbers in monetary sanctions, they came from the southern member states of the European Union, especially Italy and Spain, compared to countries like Sweden, where we did not have any records of monetary sanctions under the Directive 95/46. So quite a different picture in Europe, where Germany was somehow in the middle. We did not have high fines, and on an average we had fines with 4 digits, so like 4,000, 5,000 euros, but we never had the big cases in Germany. So this is something also the Commission has seen, and just trying to harmonize the framework for applying monetary sanctions under the GDPR to some level all the DPAs can work with. But still, even under the GDPR, each supervisory authorities will assess the case on an individual basis and can possibly set up a different fine for a breach of the GDPR. You are all aware of the current framework for applying monetary sanctions under the GDPR. Here, for a minor breach, it can be up to 10,000 euros, or in the case of an undertaking, up to 2% of the worldwide turnover of the preceding financial year. For certain infringements of the articles of the GDPR, and the bigger fine up to 20 million euros in case of an undertaking up to 4% of the worldwide turnover of the preceding financial years, for especially infringements of Article 5, 6, and 7 of the GDPR. And also, I mean, we live in times where the cross-border data transfers are being heavily discussed for breach of Chapter 5 in Articles 44 up to 49, in case you don't have an adequate level of data protection and you don't have any specific guarantee for the data subjects to make this data protection level adequate to the EU level. But still, under the GDPR, although we have very high fines up to now, and the framework has been quite changed since the GDPR is in place compared to the EU directive, each administrative fine needs to be effective, proportionate, and dissuasive. So as I referred before, it's an individual assessment by the supervisory authorities, which numbers they will take in the end and how much the fine will be in the end. But very importantly, and this has been something the GDPR has been trying to achieve, is that the high figures for monetary sanctions, they shall be dissuasive. This is something the Directive 95 and also the local national data protection laws did not quite achieve, if you ask me. Now, when we talk about DPA enforcement and the monetary sanctions in Germany, you have to be all aware of our complex system in Germany when it comes to the so-called DPA landscape here. Since we're a federal state in Germany, we do not have just one supervisory authorities, but we have 18 supervisory authorities dealing with breaches of the GDPR or Federal Data Protection Act. So each state, or as we call it here, land, has its own supervisory authorities, and depending on the establishment of a company, of controller or processor, the respective supervisory authority is responsible for the case. So this can quite vary even in Germany. So when I was referring before to a difference between the northern approach to monetary sanctions and the southern approach to applying monetary sanctions, this also could be transferred to Germany to some extent. To our experience, the northern supervisory authorities are more strict on data protection matters in general than the southern ones, being more company friendly, because many of the businesses in Germany, the exporting businesses, they reside in the south of Germany. That's why they need to be more company friendly. This is something that has been discussed in Germany. which could, in the past at least, could be stressed with numbers. Now under the GDPR, this might have been changed a bit, but we'll see it on another slide I'm going to present to you. Apart from the local supervisory authorities we have in each state or land in Germany, we also have a federal data protection commissioner at federal level, being responsible for federal institutions and also being responsible for certain sectors of private bodies, such as telecommunication institutions. The German Telecom, for example. So another complex situation here. And we also have, quite surprisingly, dedicated DPAs for the Evangelical and Catholic churches in Germany. We have an opening clause or the possibility to have a national implementation law when it comes to the churches. In Germany, it is the case that we have two main codes for data processing from the big churches here in Germany, and they also have their own supervisory authorities. So a very complex system in Germany, which leads to the requirement of a consistency mechanism in Germany. You are all aware of the consistency mechanism in Europe with the European Data Protection Board. But due to the fact that we have so many supervisory authorities, we also need some sort of consistency mechanism in Germany. That's why on the left-hand side of the slide, you can see something which we called a board of federal and Länder DPAs. It's called Datenschutzkonferenz, where the supervisory authorities are trying to get to an agreement on certain cases. But most of the publications from the DSK or the Datenschutzkonferenz, they are mere opinions. They are not binding in any way. So it's just a mechanism to make controllers of processes in Germany aware of a consistent DPA position on a certain topic of data protection. It can be Office 365, it can be any other topic when it comes to data protection, but still each supervisory authority stays responsible for the individual case and might use this publication from the Datenschutzkonferenz for the individual case, but the supervisory authority could also just have its own opinion on the matter and set a different fine for a breach of the GDPR, which makes it a bit complex. But at least it's an effort in Germany to get some consistency, to get some reliability for controls and processes when it comes to actions of the DPAs. But still, it's very complex and stays complex even under GDPR. So now when we talk about enforcement landscapes in Germany, how are the DPAs applying Article 83? You first have to be aware of that getting information on monetary sanctions from supervisory authorities is quite difficult in Germany. Why is that? Because each DPA, they publish an activity report. It's mostly an activity report covering 2 years of actions, but we don't have any standardized scheme for these activity reports. There is no central repository for monetary penalties when it comes to these activity reports. And also I have to admit that these activity reports are quite selective. So the DPA, the individual DPA, it decides which cases to publish. And when they publish cases on enforcement actions, they usually don't name any companies. They don't name any details. This has changed a bit under GDPR. Supervisory authorities now tend to publish press releases with the names of the companies and certain information on the case, but it's just very, very selective, and there are very few publications on the matter. So when I was deep diving into the activity reports of the supervisory authorities to be able to present to you some information on enforcement actions, it is quite difficult because you need to assess all the activity reports, and then you have to check a certain section, if there is one, in this report to get some numbers for enforcement actions. But then still, you are not 100% sure if it's all the enforcement action which has been taking place or not. So there have been surveys in Germany, mostly conducted by newspapers, trying to get some information. I have one slide later on presenting you some facts, but it's still very, very difficult to get information on this. But still, I tried, and I'll give you some cases on the matter. You have to add here the year of these 187 fines, which was in 2019. So there was a survey conducted by Handelsblatt, a German newspaper, asking all the supervisory authorities in Germany concerning their enforcement actions when it comes to monetary sanctions. We had overall 187 fines in 2019 under GDPR. The year before, we only had 40. And the reason for this was that the supervisory authorities were stating that we were that year in a phase where companies, controllers, or processors, they need to implement the GDPR. Still trying to change their processes to make them in compliance with the GDPR. So there was some sort of grace period granted to the controllers that no monetary sanctions would be applied, which led to a few numbers of any enforcement actions in 2018. But this changed in 2019. It will change in the future, at least when you consult publications of the supervisory authorities stating that they want to take more actions now with the GDPR being in place for 3 years. They're shifting now from the more advising aspects of a supervisory authority activity towards a more punishing enforcement activity of a DPA. And as you can see, the numbers quite vary. You have supervisory authorities, if you look below in Bremen and Schleswig-Holstein, where there were no published enforcement actions for 2019, whereas the bigger states, such as North Rhine-Westphalia, they had 65 cases of enforcement actions, 33 being monetary sanctions. And also Berlin being quite active. It is our capital with many controls and processes having 44 cases being brought to or sanctions by the DPA. But you can see that there can be some data protection shopping being conducted here in Germany. So you could theoretically choose a seat or an establishment in Germany within DPA authority, which usually has few actions when it comes to enforcement. Naming Bremen or Schleswig-Holstein. Bayern is also quite interesting. Always here on the lower side of the slide. Bayern is also a state or a land with many companies. So we have many controls and processes. There's lots of activity going on. So this is quite interesting to see that they had so few numbers in 2019 regarding sanctions or enforcement actions. The reason was, you can see it in the next slide I'm going to present to you, but I can already tell you, is that they were pretty much overloaded with requests by data subjects, or it could have been a data breach report notification. It could be a general question. They were just overwhelmed by requests by data subjects and companies. So they were not in a position to sanction anything, but just to reply to certain notifications they received or to certain questions which were raised by controllers or processors or data subjects. But it's still interesting to see that there's a huge difference when it comes to the respective state or land in Germany regarding enforcement actions. If you look at 2019, we had an average of 6,000 euros as monetary sanctions for a breach of GDPR, which is not a big number. But you will see on the next slide that there are by now popular cases which have big monetary sanctions for a breach of the GDPR. But before that, I just want to tell you briefly about the system our DPAs are working when it comes to applying monetary sanctions. We have a published finding guideline of our Datenschutzkonferenz, our board of federal and state data protection commissioners. And this paper is quite interesting because it seeks to make the controls and processes aware of the approach of a monetary sanction. And our supervisory authorities, they do classify controls and processes according to their size. They take notice of recommendations of the European Commission from 2003 and taking these recommendations into a classification of 20 groups overall, depending on usually the turnover of the company, and therefore selecting them to a specific classification scheme. So overall, we have 4 big categories of companies and 20 subcategories of these companies to get a first indication of are we talking about SME or are we talking about a really big company. Then as a second step, they are identifying the medium turnover of each group, the medium turnover of the preceding financial year, as it is stated in the GDPR. So and they are taking a functional concept of undertaking. So they're looking at the economic activity of the respective controller and processor, and then taking the median turnover of each group from the preceding financial year, and then getting to a certain amount. Then it takes this amount as basic amount and divide it by 360 days to get a, as I called it, a certain basic amount, and then they applying certain multipliers for the monetary sanction. And then they're distinguishing between a violation of Article 83, paragraph 4, or a violation of Article 83, paragraph 5 and 6, so the 20 million or 20 million, 10 or 20 million euros euro fine as a maximum. And this multiplier is applied to the basic amounts, and then they still distinguish between minor breaches and severe or very severe breaches of the GDPR. And in the end, they have an amount, a certain monetary sanction they will apply, but then they will adjust this this number they estimated with the mitigating, not only mitigating, but also other factors of Article 83, paragraph 2 of the GDPR. For example, has there been a good cooperation with the DPA in the individual case? Have there been any mitigating actions after the DPA has made the controller aware of the breach? Is it a low profitability breach of the GDPR? And all these factors can lead to an increase or decrease of the fine, which is quite interesting to see. At least it's a very interesting guidance for also companies to see how are they acting when it comes to monetary sanctions. So it's not a big, like a surprise thing they're going to see, is because it's really all numbers. It's all numbers, and each company can really get through these numbers, trying to get to a certain fine for a breach of GDPR. Now, if you look at Germany and recent public cases concerning enforcement actions, you can see that I present to you the cases with really big fines for breach of the GDPR. For example, in Hamburg, H&M, the company has been fined with 35 million euros for breach of the GDPR and our Federal Data Protection Act, because the employer has collected vast information of the private life of the employees. Here it was a call center. They were collecting information on absence, they were collecting information on the personal family life, on holidays, and this was not covered by any legal basis under GDPR. And they also had insufficient access control policies in place, which led to the information of the supervisor authority in the beginning. So it was a data breach, presenting this case to the supervisory authority. And then they fined H&M with 35 million euros, and H&M accepted. They did not challenge this before court. They accepted because they also saw this heavy breach of the GDPR, and looking at the H&M turnover, medium turnover, they probably assessed that this was quite a maybe a moderate fine the Hamburger DPA was applying here. We also had a case against Deutsche Wohnen on the right-hand side of the slide here in Berlin. Another typical case happening in the daily data protection practice and life. They had a customer relationship management in place, which did not have any archiving function. They were simply not able to delete personal information of tenants. So in the end, the supervisory authority discussed with the intendants of the supervisory authorities, and I think over 2 or 3 years, the supervisory authority was stressing that they need an archiving concept and deletion concept for this software they were using, the customer relationship management system. But in the end, they did not really follow the recommendations of the supervisory authorities, and then they were fined with 14 million euros for not complying with the data protection principles under GDPR and data protection by design and by default, because they were using a software which had not any technical guidance or any technical aspects of data minimization or applying the storage principle or limitation of storage principle. On the left-hand side, we had a case brought against a public insurer for collecting personal data of with the EU for a competition. So they were collecting personal information of persons participating in the competition and the insurer they were a part of, but then they were contacting the data subjects without consent, and they were using the software, not really applying the consent of the data subject, or if there was a consent or if there wasn't a consent. And the last popular case I want to present to you is the case against Oneonone Telecom. It is quite an astonishing case in Germany, because I just want to present it to you very briefly. We had the scenario where we had a call center of this telecommunication company, and usually callers would call this call center and authenticating via a birth date or contract number. So in case the employee of this call center was aware of, this is really the person I want to talk to. And in the particular case, an ex-partner was obtaining information on a new cell phone number from the ex-partner by authenticating to her known information, birth of date of her ex-partner. So the woman called, received the information of this new cell phone number by just authenticating with the birth date of the ex-partner, and then she massively stalked her ex-partner via telephone. And this has been brought to the attention of the supervisory authority in, I think it was the Federal Commissioner, because it's a telecommunication company. And then the Federal Data Protection Commissioner fined Oneonone Telecommunications with a fine of close to 10 million euros. Another big fine if you compare it to other fines in Germany. And the reason was an infringement of Article 32 GDPR. But in that particular case, and in contrast to the other case I just presented to you, Oneonone challenged the fine, because it was surprising for them and also to the public and also to my person that the fine was so big. It was close to 10 million euros for a technical, that wasn't an organizational procedure in a call center, which was quite common in Germany, asking for certain additional information of the caller to this call center, such as a birth date or a contract number. So Oneonone challenged this fine imposed by the Federal Data Protection Commissioner. This case has been brought to the Regional Court of Bonn, and in November 2020, the court reduced the fine for concerning Oneonone Telecommunications from close to 10 million euros to 900,000 euros, a tenth of the original amount of fine. Quite surprising to see. The court argued that it was a common practice in call centers to ask for additional information, such as a birth date, and this practice had never been challenged by the Federal Data Protection Commissioner, because usually the telecommunication companies and the Federal Data Protection Commissioner, they are in constant exchange of information, and this has never been challenged in the past by the Federal Data Protection Commissioner. They were also arguing that it was just a small set of number of person data which has been disclosed to a person without a legal basis and not on a repetitive basis. So in the end, the court massively reduced the fine imposed by the Federal Data Protection Commissioner. And also Oneonone acted in good faith, because they assumed that this was a procedure which would be common in the telecommunication sector. One final interesting thing on the case was that something very specific here in Germany. If you want to apply monetary sanctions to a controller or processor for breach of GDPR or Federal Data Protection Act, you have to rely on the Act of Regulatory Offenses. And this Act on Regulatory Offenses always seeks for a breach or a lack of supervisory authorities from upper management. And in case there is no lack of supervisory authorities from an upper management, there is no breach under the Act on Regulatory Offenses. That's why many companies always argue in Germany, well, the upper management, they have made some instructions and they have developed policies for the employers, and that was it. So they were all well instructed. Whereas the GDPR has another approach. So GDPR wants to sanction the controller processor, the organization itself, and not the people guiding or leading this organization. But if you are seeking for effective enforcement in Europe, you need a uniform approach. So the specific German approach, seeking for a responsibility in the upper management, does not help imposing fines in general. So that's why the court is stating that we have GDPR, we have a certain approach for enforcement, and this approach is targeted at the controller and processor, not the people behind the controller and processor. Only in cases of an excessive behavior of the employees, employees evolving to a processor or controller of personal data, then this could change. But in general, the company is subject of administrative fine under GDPR. So quite interesting to see, and maybe if you are planning to have this procedure or this argument against a possible fine, you probably will fail by now in Germany, because we are subject under the GDPR. That should be it for now. If you have any questions, I was just checking the chat. Fintan has something to point out. Yeah, that the date of birth might be used as ID checks because there are public records on it. Absolutely, Fintan. There has been a change of policy now in Germany. So at the moment, telecommunications companies, they are introducing a service PIN, a unique service PIN for the customers. With this number, you need to authenticate, and it's not the date of birth or any other public information there is. Thank you.